Hi everyone, I'm Aisha Rahim and I will be the moderator for today's competition. Before we start, may I ask for everyone's permission? Okay, listen, I already told you guys. Good evening to all of you. On behalf of the ILSA committee, we are very honored and grateful to have our incredible judges who, despite their busy schedules, made time to partake in the ILSA UniSZA International Moot Card Competition 2022. For judges' information, all oralists are first-timers in international mooting competition, and this will serve as a stepping stone to them in future international mooting competitions. We hope that all of the oralists are prepared and can present themselves in a healthy manner. Give your all while remaining calm and collected. Ladies and gentlemen, now let me introduce our two experienced judges for session 3. Dr. Diana Sulaiman will serve as the first judge. Dr. Diana's area of expertise is in international law, which includes both public and private international law, and she is law lecturer in Universiti Technology Mara. Next will be Dr. Aini Fatiha Roslam from University Sultan Zainal Abidin will serve as the second judge. And Dr. Aini is one of the lecturers in the Faculty of Law and International Relations, in which her expertise is in international relations field. Both of our judges' expertise are very related to our concerning case in today's competition. Okay. For everyone's information, Team 005 has already submitted twice today, and this will be their third oral submission. I hope the judges recognize how ambitious and committed they are to this competition despite their exhaustion. Before we start with the session, let me read the rules for preliminary rounds. In the preliminary rounds, each team shall argue once, either as an applicant or as a respondent, depending on the party assigned. Each team shall get a total of 35 minutes to present their case. This time shall include rebuttal and sub-rebuttal time. The division of time per oralist is left to the discretion of the team subject with a maximum of 15 minutes per oralist. The maximum time period for rebuttal and sub-rebuttal is 5 minutes. The oral submission shall be confined to the issues presented in the moot problem. Maximum scores for the oral rounds shall be 100 points per oralist per judge. No two teams will argue against each other more than once in the preliminary rounds. Both teams should be aware of the time, and the timekeeper will show you a placard indicating how much time you have left. Mr. Ishraf Hassan is our timekeeper for session 3. In this court, pursuant to the application filed in the registry of the court on 10 April 2020, whereby the government of the state of Araja instituted proceedings against the Republic of Ronavo with regard to a dispute concerning alleged violations of international law by Ronavo and in accordance with Article 48 of the Statute of the Court and to Articles 31, 44, 45, Clause 1, 48, and 49 of the Rules of Court of the International Court of Justice. The parties hereby submit to this court Araja and Ronavo have appointed their respective agents. And now, I would like to invite our first agent in the Araja team, Team 005, to start with team's short introduction and then proceed with your submission. Good luck, team. Your time starts now.
Good afternoon, Your Excellencies. May it please the Court. I am Carmen, and I am appearing alongside my co-agent in this case, of Malaysia, and my learned agents for the respondents, the Republic of Ronavo, Ms. Kirsty and Ms. Pavitra. 15 minutes, and Ms. Divya will submit another 15 minutes, and we reserve 5 minutes for the rebuttal. Your Excellencies, I will be submitting that the St. Clair Island belongs to Eurasia, and that Imaro can intervene in the case between Eurasia and Ronavo. Ms. Divya will demonstrate that Eurasia is not liable to compensate. That Eurasia is not liable to compensate the respondents for the damage suffered by the HMS Gong Hippo and the HMS Gong Jimmy. Before I begin with my submissions, Would Your Excellencies like a summary of the facts?
Yes, please.
Much obliged, Your Excellency. Eurasia is a developing country located in the northern part of the Asian continent. It is divided into two administrative areas, Yemen United in the east and President Amara in the south. Most countries consider both areas the same country. However, both areas are in conflict and are hostile towards one another. Ronoval is a developed mainland country located in North America. It is a party to the North Atlantic Treaty Organization, NATO. Both countries are parties to the Charter of International Court of Justice, the United Nations Convention on the Law of the Sea, and the Vienna Convention on the Law of Treaties. They are not parties to any other treaties. The St. Pierre Island is located 12 nautical miles off Eurasia. The island belonged to Eurasia, but has been administered by Ronoval over the course of the last 53 years, through the establishment of a lighthouse and a helipad. Imaro, a neighboring state of both Eurasia and Ronoval, claims to have consistently claimed the area of St. Pierre Island. The HMS Gonghipo is a naval ship of Ronoval. On the 10th of November 2020, it collided with one of the naval mines belonging to the Navy of Eurasia on its voyage to the Arctic region. The collision occurred in the Barents Sea, near the Kota Peninsula. The ship was severely damaged and sank into the sea, and the total loss was estimated at $125 million. Ronoval contested that the naval ship was exercising the right to innocent passage under the international law, and that Eurasia should not interfere. However, Eurasia had consistently warned the HMS Gonghipo of encroaching into its territorial waters. But the HMS Gonghipo continued to stay in that area. To safeguard the area, the National Coast Guard planted a dozen naval mines, one of which HMS Gonghipo collided with upon leaving the area. The HMS Gongjini is also a naval ship of Ronoval. On the 21st of December in 2021, it was attacked in its territorial waters by a boat consisting of 5 members of the Yemen United group. The naval ship was attacked with various weapons for about 15 minutes. 6 sailors, including the captain of the naval ship, perished. President Ronoval condemned Eurasia for this incident, but Eurasia proclaimed that it should not be held responsible for the actions of the Yemen group, which was not directly under its control. On the 24th of December 2021, Ronoval launched a concerted attack on the territory of Eurasia, in which hundreds of military assets were mobilized. The attack destroyed various military and civilian structures of Eurasia, including important harbors, oil platforms, and an airport. A number of persons, including citizens of foreign countries, were killed. On the 25th of December 2021, the president of Ronoval stated that the attack was made in self-defense in the spirit of the United Nations Charter. The act was universally condemned by all other countries, and they urged Ronoval to consult the Security Council first. On 15th of January 2022, the leaders of both countries met to discuss the incident. Your Excellencies, may I now begin my submission?
Proceed, Counsel.
Much obliged. The applicants would like to first submit that the St. Pierre Island belongs to Eurasia. We submit 2 major bases for this. First, that the St. Pierre Island legally belongs to Eurasia, pursuant to the United Nations Convention on the Law of the Sea. In Article 3 of the United Nations Convention on the Law of the Sea regarding the breadth of the territorial sea, states that every state has the right to establish the breadth of its territorial sea up to a limit not exceeding 12 nautical miles, measured from baselines determined in accordance with this convention. If I may, I would like to request for Your Excellency's attention to refer to the Statement of Facts, page 7, paragraph 6, line 3. The St. Pierre Island belonged to Eurasia. This is a fact that has been confirmed by both parties, and both parties are parties to the United Nations Convention of the Law of the Sea and are thus bound by it. Pursuant to this convention, Eurasia has the right to establish that its territorial sea is within the limit of 12 nautical miles. It was also a fact agreed upon by both Eurasia and Ronval. As St. Peter,
Council, I have a question on this point. But we also know the fact that the administration of the island has been undertaken by Ronval for a substantial period of time. What would be your response to that?
Thank you very much for your question, Your Excellency. However, the establishment of a helipad and a lighthouse is the reason behind their administration. So the establishment of these navigational aids are the supporting reasons why they say that, why the respondents are saying that this is proof of their administration over the island. However, if we refer to the case of Cambodia and Thailand concerning the Temple of Priya Vihar in 1962, it states that the burden of, I sincerely apologize. I would like to refer you to a different case instead, which is the case of Indonesia and Malaysia concerning the sovereignty over Pulau Lipatan and Pulau Sipadan in 2002. In this case, the court had observed that the construction and operation of lighthouses and navigational aids are not normally considered manifestations of state authority. In the case, the court also referred to its judgment on the case concerning the maritime delimitation and territorial questions between Qatar and Bahrain in 1994, which stated that the construction of navigational aids, on the other hand, can be legally relevant in the case of very small islands. However, in this case, the St. Pierre Island is not considered a very small island. It is a fact that it is a very small island, and thus the establishment of these navigational aids cannot be considered as being legally relevant. It cannot be considered as the respondents having done acts of sovereign nature over the island. I hope that answers your question, Your Excellency.
Proceed, Council.
Thank you very much. This leads to my second basis for this submission, which is Ronval has no proof that the St. Pierre Island belongs to it. The burden remains at all times on the respondents to produce specific proof that it has sovereignty over the St. Pierre Island and that it has carried out acts of a sovereign nature on or over the island. I would like to refer to the case of Cambodia and Thailand concerning the Temple of Priya Vihar in 1962. Here it states that the burden of proof in respect of the facts and contentions on which the respective claims of the parties are based will, of course, lie on the party asserting or putting them forward. In this case, the burden of proof lies on all times on the respondents to prove that they did perform acts of sovereignty over the St. Pierre Island. Thus, Ronval has not proven and is unable to prove that it has the right to claim the island as its own. On behalf of Eurasia, the applicants respectfully request the court to adjudge and to declare the sovereignty of the St. Pierre Island rightfully belongs to Eurasia. I will move on to my second submission of the applicants, which is Imaro can intervene in the ICJ proceedings involving both parties. This is because Imaro has the legal right to intervene in the ICJ proceedings involving Eurasia and Ronval pursuant to the statute of the court. Article 62 of the statute of the court provides that 1. Should a state consider that it has an interest of a legal nature which may be affected by the decision in the case, it may submit a request to the court to be permitted to intervene. And 2. It shall be for the court to decide upon this request. As Imaro claims that its fishermen have been fishing around the island for centuries, it has an interest of legal nature regarding the sovereignty of the St. Pierre Island. Imaro will undoubtedly be affected by the decision in this case. Hence, Imaro may submit a request to the court to be permitted to intervene in the case, upon which the court will decide upon the request. It is the opinion of the applicant that Imaro has satisfied the first requirement of Article 62 of the Statute of the Court to intervene in the ICJ proceedings involving both parties. The applicants acknowledge the right of Imaro to intervene in the ICJ proceedings involving Eurasia and Ronoval. Please, will be the end of my submission. If I can be of no further assistance to the court, my co-agent, Ms. Divya, will proceed with her submission.
Thank you, Ms. Carmen. Your Excellency, moving on to my third point, that Russia is exempt from responsibility for providing renewal damages for the HMS Konghu and compensation for the loss of the ship. Under the international humanitarian law and United Nations Convention of the Law of the Sea, operations Russia will not be liable to compensate renewal for the damages suffered by HMS Konghu. Under international humanitarian law, jus in bello regulates the conduct of forces when engaged in war or armed conflict. It is distinct from jus ad bellum, which regulates the conduct of engaging in war or armed conflict that includes a crime of aggression. Together, the jus in bello and jus ad bellum comprise the two strands of law of war governing all aspects of international armed conflicts. The law is mandatory for nations bound by the appropriate treaties. Your Excellency, please to refer to Moot problem, page number 9, paragraph 1. President Harris then ordered 3 nuclear-powered submarines and 4 aircraft carriers to relocate the Barents Sea, and President Amara, fearing the safety of his nation, called the Russian President, Mr. Putin, and asked for military assistance. It is meant that war is prohibited. The threat or use of the force against other states is also prohibited by the United Nations Charters. Since 1945, war has been seen as an unacceptable means of resolving interstate disputes. As a result, threatening a nation with a military strike is against the law of humanitarian. A state is said to have undertaken
I have a question.
Yes.
How about section out of an exercise of right for self-defense, for example, under Article 51 of the UN Charter?
Could you please repeat the questions again, Madam?
Yes. Would any country be absolutely prohibited from using any use of force, or is there any exception to this rule where country or countries in conflict, for example, is justified or allowed to exercise action out of self-defense?
Thank you. As I stated in United Nations charters, the countries there are exceptional countries, madam, but Republic of Runaway and also Russia is are obliged to follow this United Nations chartered law.
Proceed, Council.
All right. So when it violate the international law, any of the treaties to which the signatory or when it disobeys globally accepted conventions and rule. In such circumstances, a state may be found in violation of international law and subject to repercussions. Such jurisdictions are required to discontinue the legal acts right away and are also given the duty of compensating the injured. States that violate international law must also provide assurances that these crimes won't happen again in the future. And governments are legally liable for the activities of their officials and can be held accountable for their interaction with both other states and privates. A state cannot be held responsible if it acted in self-defense. So this means a Republic of Renewal threatened Russia and go against set of in article the rules on when the use of the force can be used as self-defense. The second clarification is hitting naval mines and demand full responsibility, which does not seem right from the perspective of United Nations Convention of the Law of the Sea. Sovereign water and international water since ships of all nations Sovereign water and international water since ships of all nations enjoy the right of innocent passage through the territorial and archipelagic waters. A state right to lay armed mines in the water is tempered by its obligation not to hamper the appropriate passage of foreign ships. A coastal state is entitled to suspend innocent passage to protect its national security and for the weapons exercise. But in such circumstances, the suspensions must be temporary and only in specified areas of its territorial sea. In other words, the right to do so is exceptional. If a coastal state lays armed mine in its territorial waters and fail to give any warning or notification to vessels of another state that have rights of access or passage, it will breach on its international legal obligation. Your Excellency, please refer to the Moot problem in page 9, paragraph 5. It is stated that Russia claimed that the ship had encroached into its territorial waters, and after consistent warning given out by National Coast Guard, HMS Gong Hippo failed to pay heed, but continues its stay in that area. The National Coast Guard decided to plant a dozen of naval mines to safeguard the area from further intrusion by the naval ship. Upon leaving of the area, HMS Gong Hippo collided with one of the naval mines. And for your information, the Barents Sea were not regarded as high sea, so the ship lacks legal authority to accept innocent passage. Passage is innocent so long as it is not adverse to the peace, good, or security of the coastal state. Your Excellency, please refer to the Moot problem in page 6 and paragraph 4. Ronald said even if the area was not considered as high sea, where Ronald mentioned that Barents Sea is they aren't assured that the Barents Sea is a high sea, the ship was exercising the right to innocent passage under international law. Under this condition, passage of a foreign ship shall be considered to be prejudicial to the peace, good order, or security of the coastal state if the territorial sea it is engaged in any of the following activities which renewal threat or use force against the sovereignty when renewal were given warning and refused to pay heed. So this right was well established in the principle of international law and crucial component for territorial sea regime. Therefore, Republic of Renewal is not accountable for claiming that it accidentally hit mines that were set up for security purposes. Your Excellency, if you don't have any further question, shall I move on to the fourth issue?
Proceed, Council.
All right, thank you. The fourth issue will be that Russia is not liable to compensate Renewal for the damages inflicted to the HMS Gongjini. There are currently two administrative regions in Arasia. First is President Amara, charge of South, while the second is Aman United, a paramilitary organization, is charge of the East. However, on the global scale, the majority of the nations regarded both regions as belonging to the same nation. So, the group of administration of President Amara frequently engaged in intermittent acts of violence against another, particularly near borders separating the two regions. The following actions, though not all of them, are considered acts of aggression under UN General Assembly resolution, regardless of whether declaration of war has been made. Any military occupation, invasion, or attack of territory of another state by armed force. This definition is based on three criteria, which is the act of aggression must be perpetrated by a state and can engage responsibility such state. It implies the use of armed force, and it must reach level of sufficient gravity in order to be qualified as such a security council. Thus, the paramilitary organization's Ayman's attack is not Arasia's responsibility. That's all from our team. Thank you.
Thank you, Counsel, both agents on behalf of the applicant. And may the court now invite the senior counsel on behalf of the respondent to begin the submission.
Good evening, Madam President, Your Excellency, may it please the court. My name is Kirti Rubini Morgan, and I'm the leading counsel on behalf of the respondent, the Republic of Ronawal, along with my co-counsel, Ms. Pavitra Rajasingam. I'm allocating 15 minutes for my submission and 2 minutes for my rebuttal. Your Excellency, the respondent has 4 issues to submit, and I will submit on the first and second issue, while my co-counsel will submit on the third and fourth issue. The first issue is whether St. Paya Island belongs to Ronawal. The second issue is whether Imaro can intervene in the ICJ proceedings involving Arasia and Ronawal. Unless there are preliminary questions, I will now proceed with my submission. Onto my first issue, Your Excellency, I strongly submit that the sovereignty of St. Paya Island belongs to our government, Ronawal. Our first ground is that Ronawal has sovereignty towards the St. Paya Island. In regards of sovereignty, an activity that is performed in the process of establishing a claim to territory must be carried out either by the state in the exercise of its sovereign powers, by individuals whose actions are subsequently ratified by their state, or by corporations or companies that have been granted permission by the state to engage in such operation and therefore carried out on behalf of the sovereign. Your Excellency, in the same light, the development of helipads and lighthouses by Ronawal, both of which are controlled by the government, represents the sovereignty, since it reflects the desire and their will to operate in that role. Your Excellency, I would like to refer to the case of Eastern Greenland, where the court observed the territorial sovereignty of the St. Paya Island, according to how sovereign rights are exercised. Your Excellency, the applicant cannot claim that their fishing rights as the sovereign exercise because there's no contrary evidence that could prove the fishing activity under the applicant, compared to our government having physical evidence of their sovereign rights activities on the island. According to Article 137, Clause 1 of the United Nations Convention on the Law of the Sea, diverse actions by a state are required for claiming sovereignty. Our government has established a title of sovereignty over the Saint-Paya Island through a succession of sovereign activities. Next, our government has a robust military capability, which is enough to prove that our government ensures peace and no invasion to take the place of their territory. Our government has fulfilled the acquisition of territory by prescription, where it is the peaceful and continuous exercise of sovereign activities for a long time over Saint-Paya Island to the sovereignty over the applicant. Your Excellency, the pattern of state authority that our government has exercised is very appropriate in the aspect of the character of the Saint-Paya Island being established with a lighthouse and a helipad. Excellency, if there's no further questions regarding my first ground, I'll move on to my second argument. Our second argument is that Arasia's silence constitutes to acquiescence. Your Excellency, acquiescence is the act of no interruption by the applicant. According to McGibbon, it is where the form of silence generally calls for a positive reaction, signifying an objection. The applicant has not shown any protest in the existing establishment by our government throughout 53 years. According to paragraph 6 of the Moot problem, our government, the Republic of Ronawal, has controlled the Saint-Paya Island for 53 years with no interruption by the applicant, the state of Arasia. Your Excellency, the establishment of a lighthouse and the helipad throughout 53 years with no interruption concludes the acts of acquiescence on behalf of the applicant. They have not shown any protest in the existing establishment. Our government...
I have a question to ask. So I can see just now that you have quoted McGibbon as your authority to support your argument on acquiescence. Is this a valid source of law that you could bring? And do you have any other authorities to support your argument?
Your Excellency, McGibbon is a writer on the principle of acquiescence. So I submit that it is a valid authority to justify my claim. Yeah, that's it from me. May I move to my second argument?
Yes, proceed, Councillor.
Your Excellency, our second argument is that Arasia's the third ground, I believe. Your Excellency, is that the applicant claim on their cartographer is insufficient to prove their sovereignty over the Saint-Paya Island. Here, we would like to highlight the paragraph 8 of the Moot problem. Here, the applicant claimed that their cartographer had delineated the boundary of both countries. However, Your Excellency, according to the Botswana against Namibia case in 1999, the court shall not conclude the cartographic material given the absence of any map officially reflecting the intention of the parties and in the light of the uncertainty and inconsistency of the maps submitted by the parties. Your Excellency, hence, this proves our government has the actual exercise of sovereign right on the Saint-Paya Island. Therefore, we firmly submit that the sovereignty of Saint-Paya Island belongs to our government. Your Excellency, I will now move on to my second issue. Here we submit that IMARO cannot intervene in the ICJ proceedings involving Arasia and Ronaldo. Your Excellency, our first argument is that IMARO does not have any legal interest which may be affected by a decision in our case today. Your Excellency, according to Article 62 of the Statute of ICJ, a state shall consider that it has an interest of a legal nature that may be affected by the decision in this case. For example, I would like to quote the Continental Shelf case. Here, the court shall consider that the interest of a legal nature that IMARO had to invoke could not be affected by the case interest of a legal nature. However, Your Excellency, IMARO failed to express its own legal interest in the case and how that interest is related to the decision of the court that could make at the conclusion of this main proceeding, as required by the statute and rules of court. Your Excellency, in the case of Nicaragua against Colombia, Costa Rica has designated the sea zone where it feels it has a legal interest that might be affected by the court's decision on the primary issue of the case. However, the court will not let Costa Rica to intervene, notwithstanding the marine areas designation. Therefore, in accordance with Article 62 of the statute, IMARO's attempt to intervene was unsuccessful because it failed to prove that it had a legal interest in the Saint Pierre Island. That was the focus of a legal claim that the judgment in the main proceedings may influence this interest. Hence, IMARO cannot intervene in the ICJ proceeding involving Arasia and our government Ronaldo pursuant to Article 62. Your Excellency, our government's second argument is that there is insufficient reason by IMARO concerning their rights that have been affected. Your Excellency, in the current case, IMARO claimed that their fishermen have been fishing around the island for centuries without objection from any countries. IMARO only stated its concern that their fishing rights will be affected by the court's decision in the dispute between Arasia and our government. Thus, IMARO has failed to identify and also to prove its interest of legal nature that will be affected by the court's decision pursuant to Article 62. Your Excellency, I would like to refer to the case of sovereignty over Pulau Ligitan and Pulau Sipadan by the Philippines. IMARO did not expressly state its ownership or sovereignty over Saint Pierre Island, hence leading to IMARO to disavow interest of legal nature in the actual subject matter of the dispute, which is currently pending. A legal interest as defined by Article 62 is not afforded the same protection as an established right, nor is it subject to the same standards of evidence. Therefore, IMARO cannot use or apply Article 62 to intervene. Your Excellency, the third ground that I would like to put forward is the absence of a precise object of intervention by IMARO. Here, according to Article 81, Clause 2, subsection B of the ICJ Rules of Court, an application to intervene under Article 62 must set out the precise object of the intervention. However, IMARO's situation contradicts with the case of Nicaragua, where the application of Article 62 was successful in that case. However, while in IMARO, there clearly has no precise object of intervention because IMARO did not set out interests of legal nature which may be affected by the decision of this case. Therefore, IMARO cannot apply Article 62 to intervene. Therefore, Madam President, Your Excellency, I firmly submit that MRO cannot intervene in the ICJ proceedings involving the applicant and also our government, the Republic of Ronawo. Your Excellency, if I can be no further assistance, I will now yield my stand to my co-counsel, Ms. Pavitra.
Before that, Council, if I may ask a question here, I believe you did make mention about the submission of your rebuttals. Would that be undertaken by the senior or the junior counsel?
I will do my rebuttal after the applicant's rebuttal, Your Excellency.
So that will be so after the junior counsel on behalf of the respondent has submitted, the rebuttal will be or rebuttal session will begin with counsel on behalf of the applicant, and after that, counsel on behalf of the respondent would provide the rebuttal. So that would be the order. Yeah, thank you very much. Proceed, counsel.
Am I audible?
Yes, counsel.
Good afternoon, Ms. President, Your Excellency, may it please the court. I'm Pavitra Rajasingham and the co-counsel on behalf of the respondent. I'm allocating 15 minutes for my submission and 2 minutes for the rebuttal. Your Excellency, I will now submit the third and fourth issues. The third issue is whether ARASIA is liable to compensate Ronawo for the damage suffered by the HMS Gong Hippo. The fourth issue is whether ARASIA is liable to compensate Ronawo for the damage suffered by the HMS Gong Jenny. Your Excellency, now I will proceed with my arguments. Regarding the third issue, we submit that ARASIA liable to compensate Ronawo for the damage suffered by the HMS Gong Hippo. Our first argument is that HMS Gong Hippo has the right to innocent passage to sail freely into the territorial waters of ARASIA without interference. Article 19, Clause 1 of the UNCLOS defines what it means for a passage to be innocent. It indicates that a passage is innocent as long as it does not compromise the peace, good order, or security of the state it passes through. Ships from all states, whether coastal or landlocked, are granted the right of innocent passage through the territorial sea by Article 17 of the Convention 1982, which deals with the right of innocent passage of the states. Your Excellency, I would like to refer to the case of Portugal against India, where the court held that Portugal had, in 1954, a right of passage over intervening Indian territory between the enclaves of Dadra and Nagara Haveli and the coastal district of Daman, and between these enclaves to the extent necessary for the exercise of Portuguese sovereignty over the enclaves and subject to the regulation and control of India in respect to private persons, civil officials, and goods in general. Your Excellency, in the current case, the GMS Gong Hippo, exercising its right to innocent passage under international law, was assaulted due to the naval mines belonging to the Navy of the ARASIA. Concerning the case of Portugal against India, ARASIA stated that the placement of naval mines protects the region against future incursions by naval ships. Still, Ronaldo does not threaten the security, tranquility, or order of ARASIA as it transfers. Article 14 of the 1958 Convention on the Law of the Sea explains that the coastal state must not obstruct innocent passage and warn of any navigational dangers in its territorial sea. However, in the current case, there is a loss of life and property of Ronaldo. Therefore, ARASIA is liable to compensate Ronaldo for the damages. Your Excellency, our second argument is that HMS Kong Hippo was on the high sea and had the freedom of navigation. Your Excellency, I would like to refer to Article 1 of the 1958 Geneva Convention on the High Seas, which actually explained that all sea areas not a component of a state's territorial sea or internal waters are referred to as the high seas. Next, Article 87, Para 1, Lit A of the 1982 United Nations Convention of the Law of the Sea explained that high seas are accessible to all nations. Besides that, Article 2, Para 1 of the 1958 Convention of the High Sea stated that high seas are available to all nations. No government can legitimately claim control over any portion of them.
Councillor, I have a question. Are both parties, Ronavol and Araja, state parties to all the treaties that you have mentioned just now,
Yes, they are.
including the 1958 treaty that you just mentioned?
Yes.
Proceed, Councillor.
Thank you. I would like to refer to John Sheldon, an English academician. Your Excellency, he stated that a state cannot restrict other people from using its ocean without failing in its obligation to humanity. Your Excellency, I would like to refer to the case of United Kingdom against Albania, which is also well known as the Corfu Channel case, where the court held that the mines could not have been set without the Albanian government's knowledge, even though it did not accept the idea that Albania had laid the mines or given authorization to another entity. As a result, it was determined that the Albanian government had approved the mine's placement, and as an outcome, it was mandated to pay compensation to the United Kingdom. So in the current case, Your Excellency, Arasia claimed that the ship had entered its waters without authorization, violating its territorial waters. But citing Article 87 UNCLOS 1982, the naval ship, which is HMS Gong Hippo, is free to travel to another nation, any other nation, and is allowed it to be on the high seas, just like every other nation. The argument that Arasia and Ronawo do not have any official diplomatic relation should not be considered, because the sea is not a country or a personal legal property. It is actually open and available to everyone on the earth. As cited in the Corfu Channel case, Arasia, as the neighbor state to Ronaldo, should have noticed the naval mines earlier. The placement of the naval mines in the region was actually immaterial. With this, we submit that Arasia is liable to compensate Ronaldo for the damage suffered by the HMS Kong Hippo. Your Excellency, I will now move to the second issue. We submit that Arasia is liable to compensate Ronaldo for the damage suffered by the HMS Gong Jenny. Your Excellency, our first argument is that Arasia has disregarded the state's responsibility. In State Responsibility 2001 Act, it is stated that to establish state responsibility under international law, the conduct must be attributable to the state and meet the criteria for a wrongful act under the rules of international law. According to Article 42 of the Responsibility of States for Internationally Wrongful Acts, an aggrieved state is any state that has violated its right by an act that was committed by another state, provided that the act meets the criteria for being considered any internationally wrongful act committed by the state. Your Excellency, the attack on a Navy ship belonging to Ronaldo, the HMS Gongjani by Amen United while operating within Ronaldo's territory waters was unethical on the part of Amen United. Arasia's employment of a wide variety of weapons proves that the country has violated a legal responsibility. The territorial sea in Asia should be protected by aggression. Yet, Arasia's use of aggression does not demonstrate that it is being practiced to safeguard the sea. Your Excellency, our second argument is that HMS Gongjani has the right to innocent passage to sail freely into the territorial waters of Arasia without interference. Your Excellency, I would like to refer to Article 14 of the Convention on the Law of the Sea 1958, which emphasized that the coastal state must not affect innocent passage and must publish any dangerous to navigation in the territorial sea of which it is aware. Ships from all states, whether coastal or landlocked, are granted the right to innocent passage through the territorial sea by Article 17 of the Convention 1982, which deals with the right to innocent passage of the sea. So, Your Excellency, in the current case, a boat with 5 members of the Amen group on board assaulted a Navy ship from Ronaldo. At the same time, it navigated in Ronaldo's territorial waters on the 21st December 2021. The crew of the attacking boat utilized a wide variety of firearms, including rocket launchers, assault rifles, and machine guns. Due to the attack, the assault successfully destroyed the front section of the Navy ship, which included the upper deck. Arasia's action was discovered in retrospect that the internal fire on board and the Navy ship was responsible for death of 6 sailors, including the ship's captain, uh, HMS Gongjani had been navigating on its territory and it had all the right to innocent passage. But because of the attack, the ship was damaged and loss of life. Therefore, Arasia is responsible for compensating HMS Gongjani and the family of the deceased sailors. Your Excellency, if there is no further assistance, that summarize our argument. Much obliged.
Thank you, Counsel. Representative, on behalf of the applicant, are you ready with the rebuttal? You may begin whenever you're ready.
Thank you, Your Excellency. So applicant team will be rebutting 5 of the points that were mentioned by our respondent team. The first issue would be on sovereignty of sand period. Russia has not claimed that fishing activities is a proof of sovereignty. Refer to the statement of fact, it does not denote that the fishing activities is an act of sovereignty. So the burden of proof at times lies on Ronaldo to prove that they have performed the sovereignty. According to Moot problem, page 7, paragraph 6, line 3, the Saint Pierre Island belongs to Arusha. This is the fact. So, outstanding issue of the territorial infringement, claim of Saint Pierre, an island located 12 nautical miles off Arusha. The second issue would be on Arusha's silence does not equal to acquiescence. According to Article 21 clause, the coastal state may adopt law and regulation in conformity with the provision of convention and other rules of international law. And the thing is that the protection of navigational aids and facilities and other facilities or installations. Russia is acting in compliance with the clause. And referring to the case of sovereignty over Petra Branca and Pulau Batu Putih. where the court ruled the Petra Branca is under Singapore's sovereignty while Middle Rocks belongs to Malaysia. The third issue is that cartographer does not prove sovereignty over Saint Pierre Island. The burden of proof lies within Ronawol, not Erasia, to prove their sovereignty over the island because they are the one who make the claim over the highland. The fourth issue would be innocent passage. For your information, the Barents Sea were not regarded as high sea, so the ship lacks legal authority to assert innocent passage. And yeah, Amen United is not responsible for Arasia. Innocent passage in territorial sea can refer to subsection 8, where the rules applicable for all the ships. The fifth one is a ship from Amen Group that attacked HMS Gong Hippo. Arasia would not liable for the Gong Hippo damages because paramilitary group of Amen is the Arasia is filled with two regions, which is known as one is known for the south and another one is for east, and we are following de facto boundaries, which is also known as countries that define the area, and the government is actually able to enforce its law in and to defend against encroachments by other countries that may also claim the same territory de jure. And the final one is no interruption of renewal, establishing navigational aid and chasing away fishermen. Arasia had no reason to interrupt renewal, shown acts of hostility, but Arasia chose not to. Thank you, Your Excellency. That's all from us.
Your Excellency, the respondent has one point to make in regards to the applicant's claim that Ronawol does not have any proof that the Saint Pierre Island belongs to our government. We submit that according to Article 137 Clause 1 of the United Nations Convention on the Law of the Sea, diverse actions by the state are a requirement for claiming sovereignty. Our government has established a title of sovereignty over Saint Pierre Island through a succession of sovereign activities, such as the establishment of helipad and lighthouse, and uninterrupted establishment through a solid 53 years. Your Excellency, based on Huber's theory, Your Excellency, our government has exercised state function by not allowing applicants fishermen on the territorial sea Saint Pierre Island. Our government have also exercised a peaceful display on the Saint Pierre Island by peacefully making the applicants fishermen leave the area instead of launching an act of aggression on the fishermen. On the second issue, Your Excellency, Imaru does not have any legal interest which may be affected by a decision in this case. We still submit that Imaru's claim on its interest is not the object of a real and concrete claim of the Saint Pierre Island. Your Excellency, to determine the scope of Imaru's intervention, that is reasonable under Article 62 of the statute, the court must evaluate the possible effect of its eventual judgment on Imaru's legal interest. Imaru may convince the court that it has a legal interest that may be impacted by the case result, and it may be permitted to intervene to defend this interest. However, Your Excellency, this does not mean Imaru may investigate other aspects of this case. The court must determine the scope of an admissible Imaru's intervention. So this concludes the respondent's submission. May it please the court.
Thank you, Counsel. And the court is now adjourned. I was just wondering if the a member from the organizing committee normally would, yeah, I think, yes.
Alright. Yes. Thank you, judges and both applicant and respondent team. With that, that concludes session 3 for today's oral submission. I would like to remind all of the judges to email us the score sheet as soon as this session ends. As a member of the ILSA committee, I would like to thank Dr. Diana and Dr. Aini for sitting down with us as judges in this competition. Thank you all and have a good day.
Miss Aisha, I was just wondering
Yes.
if I can make a quick remark to the to all the participants today. Would that
Yes,
be
sure.
permitted?
Right, but we can only how do I say this? We have to stop at 4:10 sharp.
Okay.
Is it okay with you?
Yeah,
Is
hopefully
it okay, Dr. Diana? All right.
Yes, just 1 minute probably. I want to take the opportunity to congratulate all Mooters that have completed the submission today very successfully. Your case, both on the applicant and respondent side, were well argued. And congratulations to everyone. It was such a joy and delight for me to sit here in this session to adjudicate this round. Thank you very much. Thank you.
Thank you, Doctor.
Thank you very much, Dr.
Thank you, Dr. Diana. And thank you, Dr.
Thank you,
Aini.
Dr. Diana.
Thank you.